I would first like to invite Professor Faizan Mustafa to offer his comments as chair on Justice Oka's lecture.
Good evening. Thank you very much, Pritam. What an excellent lecture and treat we had from Justice Oka. And it's an honor to speak when Professor Gurpreet Mahajan is here. All of us have understood and read multiculturalism through her writings. Now, I have a difficult task to make comments on a lecture which is very settled, given by one of the best judges of our times. I'm reminded of Edison, who said, "To be perfectly just is an attribute of the divine nature. To be so to the utmost of our abilities is the glory of man." Now, this is the apt description of nature of judicial function. And whenever I see and hear Justice Oka, I'm also reminded of David Penick's book, Judges. The qualities desired of a judge can be simply stated that he be a good judge and that he be thought to be so. Justice Oka fulfills both the requirement. He is a good judge, and we all have great admiration for him. Now, teachers are one in the habit of to be, if they're real teachers, to be more blunt and less diplomatic. That's how, Chanakya was able to speak truth to Dhananand in Magad. The whole question is, this evening, that how come unelected judges should be able to overturn and overrule decisions made by the elected representatives of the people. Because the legislature, the parliament or the state legislatures, and the executive, they are rightfully said to be representing the popular will. And judges definitely don't represent the popular will. But I'm reminded of a conversation about which historians differ. Some say that this conversation between Stuart, King James I, and Chief Justice Coke never took place. But this is how it went, that the king wanted to say that he can decide cases himself. And the archbishop was having some dispute with judges, and he said it's better if instead of judges, the British monarch himself decides. Now, Chief Justice opposed it and said, king cannot decide. Then king replied, James I, that he thought the law was founded on reason, and that he and others had reason as well as the judges. Coke then said, according to the account in the 12th report, that true it was that God had endowed His Majesty with excellent science and great endowments of nature. But His Majesty was not learned in the laws of the realm of England, and causes which concern the life or inheritance, or goods or fortunes of his subjects. They are not to be decided by the natural reason, but by the artificial reason. And the judgments of law, which law is an act which requires long study and experience before that a man can attain to the cognizance of it, and that the law was the golden metwen, and the measure to try the causes of the subjects, and which protected His Majesty in safety and peace, with which the king was greatly offended, of course. And he said, then he should be under law, which was treason to affirm. Now, this is the reason why judges should have powers, because if they exercise their powers properly, then there will be peace. The king would also stand protected. And because they are trained in a particular kind of reasoning which others are not trained in. Now, within the political scientist, for long there has been this whole debate that this idea of separation of powers is a kind of an illusion. In parliamentary democracy, Parliament does not control executive. As all of you know, which bills will come before Parliament? The government will decide. What would be the duration of House? Government will decide. And you know, lately, Parliament and state legislatures are passing laws in 5 minutes, in 3 minutes on an average. The number of days they sit is, with every passing year, getting reduced. And most of the time when they are having sessions, they are just opposing each other rather than doing the legislative business. The point I'm trying to draw home is that there is a core function of each branch. The other branch is not supposed to interfere with the core function. But at times, if the other branch is not working well, probably it has to interfere sometime. The problem which many democracies are facing, particularly in Latin America, in number of Asian countries, is not whether the judges who are not elected should have power to sit on judgments of people's representatives. The challenges to which His Lordship made a passing reference, you were given a task. Ultimately, you can't be saying that this whole constitutional system has come into being without some settlement. Now, that settlement has a popular approval. Of course, Indian Constitution was never referred to us in referendum. Of course, our representatives, directly elected representatives, were not sitting in the Constituent Assembly. Nevertheless, by participating in elections after elections, people of India have impliedly endorsed this Constitution. And in terms of representative character, the Constituent Assembly had representation of almost all sections of our population. So we, people, agreed to some kind of arrangement. That is, in my opinion, is the legitimacy, and judges too have that popular will in support of their powers to sit on judgment. So we made an agreement that, okay, you will make laws, and you will execute laws, and you will make sure this power itself has come from the people, who are the sovereign, that you will ensure that legislature and executive does not transgress its limits. People's rights are not violated. Supremacy of the Constitution is maintained. That is a task which has been given to them. The problem which we are facing is that are judges doing enough to protect the democratic character of the Constitution? There is a difference between majoritarianism and democratic governance. Justice Oka rightly made a reference that elections, and look at that, in most places you will not have more than 50% people even voting. How governments are formed, rarely a government has support of 51% people. Because you have a multi-party system, if you have about 37, 38% of votes, you will form a government with big majority. Look at the current Bihar election. The highest number of votes, about 23 point some percent, went to RJD, but it got just about 25 seats. So whether the elected government really represents the will of the people is also questionable. But assuming that this is a system which we have, in that system, we have to make sure that, as Lord Acton said, power corrupts, and absolute power corrupts absolutely. The judges have been given the task that they make sure that the governments of the day do not go against the Constitution. How come our courts are not even reacting, even though they are said to be more executive-minded than the executive itself, when somebody says that Supreme Court is using power of 142 as a nuclear missile? Or another politician says that the Supreme Court is leading country to a civil war. This is dangerous, in spite of all the judgments they have given, which have gone in favor of the government. So judges are also people's representative because of that covenant, which is called the Constitution of India. They hold office not during the pleasure of president, but during good behavior. And their good behavior is that they stay firm, and they stay independent, and they remain committed to the Constitution. What is really happening that word over, there is weakening of democracy which is happening. So many books have been written how democracies die. Are judges contributing to that weakening of democracy is the question. The question today is not that how can unelected judges sit on judgment on the decisions of the elected representatives of the people. Are judges themselves, by not asserting their power, weakening the democratic governance in itself? What are they doing to ensure that various constitutional agencies which conduct the election remain independent? How come when a judgment of a Supreme Court within 2 weeks or so is overturned through an ordinance, Supreme Court refuses to even examine it or put any stay on it? I understand that in the judgment itself, Justice Chandrachud has opened a window that, okay, our observations are till the Parliament comes up with a law, and Parliament is free to come up with any law they want to bring in. But this is the real challenge, which I believe we need to understand. The other issue which which a reference was made by Justice Oka, this whole talk of fundamental duties and fundamental duties being more important than fundamental rights. Liberal constitutions in the world, democratic liberal constitutions, don't have a provision of fundamental duty. Fundamental duties are the relic of socialist constitutions, authoritarian constitutions. We did not have it. We criticize 42nd Amendment for inserting words secular and socialist, but we celebrate insertion of fundamental duties. Indian Constitution, even Mrs. Gandhi, at the peak of her power, could not include fundamental duties within fundamental rights and make them correlative in the typical positivist sense that, as you can't have a father without a son or a wife without husband, you can't have a right without a duty or a duty without a right. We don't have that kind of thing. In India, traditionally we were saying that we are a kartavya pradhan desh. Even in Mahabharata, Arjun was saying that he was not able to convince Arjun in the name of a right to the kingdom. It is only when he said it is your dharma to fight your own cousins that he was able to convince Arjun. Therefore, to me, we should not confuse majority government with democratic governance and equate periodic electorate return of the will of the people. If integrity of electoral rolls is controversial, if the election commission is not independent, if freebies are offered before elections, if there is use of money power, muscle power, religion, and what Ravish Kumar says, Godi media, then of course, the government which gets elected may not have the same kind of legitimacy which in a typical classical democratic governance a government would have. The idea is if you are really democratic government, then between judiciary and you will have a greater right because you represent people. Democratic leaders don't like judicial review. Even Pandit Jawaharlal Nehru in the Constituent Assembly itself said, if we go wrong here and there, Supreme Court can point it out. But if it come in way of sovereign will of the people, represented by us, then we appoint judges. And then Mrs. Gandhi, at least twice, indulge in what is said to be the supersession of judges. Going back to the question, how do people look at court? The legitimacy to the court's role comes from their independence. Independence of judiciary is not the right of judges. It is the right of the people. We want you to be independent. If long, his lordship was talking about bail, long adjournments for bail, people not getting bail for 5 years, 6 years, trial also not taking place. That's not good. Democracy is all about freedom of speech. Everybody should have a right to speak. The Constitution talks of making of new states, bifurcation of states. 2 days ago, Supreme Court was talking about dialogue in the presidential reference between the governor, who is by and large agent of the center, and a democratically elected government. His silence, as Pratap Bhanu Mehta would say, is also part of a dialogue. He can simply sleep over for months together, and a democratically elected government won't be able to do it. In Article 3, the only power a state legislative assembly has when a state is going to be bifurcated, expression of opinion. We even deny that. And such a major issue, Supreme Court did not answer in 370 judgment. Number of cases, of course, governments win cases. There is no harm if, by and large, there is presumption of constitutionality. We presume that legislature has done its homework. I'm just finishing, Pratham, just 2 minutes. But look at 6A judgment. Assuming government had opposed 6A, probably the judgment would have gone the other way around. Because there are people who are saying that the citizenship, even in Assam, should be determined on 19 July 1947 or 1st March 1947, not 25th March 1971. Sealed cover is back, the whole Vantara thing. Review is accepted if government is interested. The court does not bother about its own judgments. No error in the Sabrimala judgment was pointed out. Yet the review was accepted. The law is very clear that Muslims cannot be scheduled caste, even though this is a discrimination solely on the basis of religion. But at least as the law stands today, Muslims can be scheduled tribe. If there is a Muslim who is a scheduled tribe and it is his property, why can't he create waqf? And therefore, Supreme Court's judgment, this interim order, is disappointing on more than one count. What I am trying to, equality of marriage, one Shakti, an excellent judgment from his lordship, getting overruled. And then I will close on this. One feels sad to see the justification of judicial powers comes not just keeping government in check, giving justice to ordinary people. For years, I have been thinking that Muslim women have a better chance of success in our courts than the Hindu women. In number of cases like this, if they don't put sindoor, then it is cruelty. Husband is entitled to divorce. If they say that we will not live with mother-in-law, they say it is cruelty. And the case which comes to my mind, that if you are a Hindu issueless couple and you die, the property of husband will go to husband's heirs, but the property of wife will also go to the husband's heirs. And in this case, husband died due to a snake bite, Om Prakash case I am talking of. The in-laws threw her out of matrimonial home. She was educated by parents. 42 years in-laws did not return, did not ask her welfare. She becomes a school teacher, gets gratuity, pension, constructs house, makes some savings. And on her death, Supreme Court does no judicial activism and say we are bound by the legislative scheme, and the property of this lady was given to in-laws. The presidential reference, does it really strengthen democracy? Who represents democracy? Governor or the chief minister who is elected by the people? And therefore, I think that we have to see that in addition to promoting constitutionalism, ensuring supremacy of the Constitution, are judges really adjudicating with fairness? Thank you very much.